welcome all of you, all the participants, the panelists, and everyone who has joined today to this 5th edition of our monthly webinar series. As you're aware, we bring this webinar, which is basically micro nuggets of information, which are relevant to your business, your education, and to academics, to you through collaboration with the Bangalore Chamber of Industry and Commerce, as well as the MSME directorates of Bangalore and Thrissur, which is basically Kerala and Karnataka. So with that small brief, today it's a little bit of an unusual day because we usually hold it on a Saturday morning, and Saturday morning is kind of a lazy morning, everyone gets in. But Friday is evening is this the first time we are trying. That's because we have a very special guest with us, and he's based out of US, and I'll introduce him very shortly. But that's the change we have done. But you know, it's a great occasion to welcome him. But before I kind of introduce him, I would like to spend a few seconds on the housekeeping rules. You will all be put on mute. So if you, the format of this whole program is, first I'll introduce the speaker, and thereafter I hand it over to Dr. Krishnasri Achyutan. Dr. Krishnasri Achyutan is the Dean of our university, who will welcome all of you, and also Dr. Nag, to this evening of discussion and presentation. Thereafter, after the presentation is done, Dipanjan Nag, Dr. Dipanjan Nag is going to hand it over to me, and I'm going to ask him some questions. These questions are not meant to be, you know, all the questions that the participants have. Is just to trigger some thoughts, and you will actually ask those questions. Please type in the questions in the question and answer chat box. So below your screen, you will see 2 chat boxes. One is chat, which is general chat, and second is the Q&A. Please type in your questions in that question box, and I will handle the questions. Ask Dr. Nag about his insights, and then we'll carry it through. The program is likely to be about 1.5 hours, and all mics will be muted. With those housekeeping rules done, let me now introduce you to Dr. Nag. Dr. Nag, I mean, the introduction is very brief because of paucity of time. It could have gone on and on, but you know, just on the brief, Dr. Dipanjan Nag is the Chief Partnership Officer of Ventech Solutions, a company which is a healthcare tech company based out of US. He is also the leading mind in the patent monetizing company Innovatio LLC. Dr. Nag actually brings in years of tech transfer experience, and these technology transfer experiences have been in various universities all over US and elsewhere, but amongst others, it's Ohio, Rutgers University, and Nebraska University. He has been an entrepreneur himself, and he has lived that life of an entrepreneur. He's an IP strategist and was elected to the board, the governing board of Autumn in the year 2012 to 2014. He is widely recognized all over the world as an IT strategist, and has worked with various governments and universities in various countries, including Japan, including Ukraine, including Brazil, and just to name a few, Korea, and of course, India. He is the professor in practice for Rutgers University, and is a visiting professor of Shizuoka University in Japan. That's a brief introduction. There's lots I can talk about Dr. Nag, about his various rich and varied experience. But with that, I will hand it over to Dr. Krishnasri Achyutan to speak a few words and welcome Dr. Nag as well as the participants to this evening webinar. Over to you, Dr. Achyutan.
Thank you, Joydeep Nag. It's a pleasure to really host this event today. We are very much looking forward to learning about IP rights and management from really one of the most renowned experts in the area, Dr. Dipanjan Nag. To just briefly mention about the Amrita Vidyapeetham and Amrita TEC. Amrita Vidyapeetham is one of the youngest, fastest growing universities in India. Today, it is ranked as the 4th best university in the country by the national ranking framework designed by the government of India, and also internationally in the impact rankings. We are in the top 100 universities in the world, especially with regard to several different sustainable development goals, such as gender equality, quality education, infrastructure, good health, etc. And I think the Technology Enabling Center actually sits in between the university and the, you could say, its ecosystem partners to be able to bring about technology commercialization, technology development, and also awareness of intellectual property to as many innovators as possible, both in India and outside. And this seminar is one important, you could say, endeavor in trying to bring up the awareness and education of people engaged in innovation for intellectual property is one of the most critical things that any and every innovator should know about. So with that, again, warmly welcome all the participants and also Dr. Dipanjan Nag to this seminar.
Over to you, Dipanjan, for the presentation.
Well, thank you very much. It is really an honor and pleasure to be with you this evening, India time. And thank you, Dean Krishnasri, and thank you, Joydeep, for bringing me here today to discuss a very important topic that is very close to my heart. I left India way back in 1992, and since then I've been spending a lot of time in the US, both in the scientific side and the academic side, as well as on the corporate strategy side. And I've seen, like Joydeep mentioned, quite a few innovation ecosystems around the world, advising them on innovation and intellectual property strategy matters. And the underlying theme in every economy that I go and speak with or do advisory work is the challenge with innovation and the challenge with entrepreneurship. And fundamentally, what I can tie those two down to is the absence or lack of policy level initiatives on the intellectual property side. And based on my talk this evening, you will hopefully get a recognition of why intellectual property is important. Because most people don't have a fundamental understanding that innovation is basically directly proportional to intellectual property for an economy to be sustainable, successful, and become a knowledge economy. So with that, let me just share a few slides with you so I can make my point this evening to you. Are the slides visible, Joydeep?
You're fine. You're fine.
Okay, excellent. Okay. So let me take you to fundamentally what research I have done, we have done. I used to be with a company called Ocean Tomo out of Chicago, and we created a field which was essentially the valuation of intellectual property assets. And if you look at the top 500 companies in the United States, that is clustered together in the stock market as the Standard & Poor's 500 companies. These are the most valuable companies, definitely in the US. In certain instances, they are the most valuable companies in the world. So if you look back in the 1970s, you will see that only about 20%, actually 17% of the valuation of that entire company on an average was intangible assets, meaning the ideas, the innovation, the intellectual property, the trademarks, all of that clustered together only comprised of 20% of a company's valuation. That's not a whole lot. The reason for that, if you look at it in the US, at that point in time, US was really a manufacturing economy. And fast forward, you go 30 years, you see that slowly but surely the intangible valuation of a company has now gone up to 80% of a company's valuation as opposed to the 20%. In our words, we call that an inversion of the economy. What that means is a country going from a manufacturing predominant economy to a completely innovation or knowledge economy. And let me give you one example. If you take the example of a company like Uber, which actually has quite a bit of presence in India. When I go to Kolkata, I ride Uber a lot. What does Uber have? End of the day, they don't own any real estate property. They don't own the cars. They don't have the drivers as their employees. So what is it that they own? Well, I would argue to you, Uber basically is an innovation intellectual property company. That's what it is. So look at now companies like Airbnb, which has also got some presence in India, as I understand. And Airbnb is basically, if you had a very nice home in Bangalore, and you wanted to rent that out to someone who's coming in for a visit, you could do that. And you do that through Airbnb. That is the platform. The intellectual property that drives that platform is the value for Airbnb. And truth be told, Airbnb valuation is actually more than the Hyatt hotels worldwide, without a single building ownership by Airbnb. So these are some of the examples of companies which have become now almost ubiquitous in your life. Say, for example, Google. Do they have some tangible assets, servers and buildings and such? Yes. But overall, they are a company based on intellectual property. So in 2020, that is even more extreme based on the latest study by Ocean Tomo. 90% of the S&P 500 companies' valuation is actually intangible assets. And that includes intellectual property in there. Now, let's take a slightly bit more deeper dive into who are these companies that get selected in those S&P 500 and who are the top ones. So let me just take a look at 2018, and you will notice Apple, Alphabet, which is Google, Microsoft, Amazon, and Facebook. All 5 of those companies are basically fundamentally running on their intellectual property assets. And the valuation, if you look at it in 2018 of the S&P 500 companies, overall was $25 trillion with a T. That's staggering. $1 trillion is larger than some of the GDPs of some countries. So $25 trillion is obviously a lot of value. And that of that $25 trillion, $21 trillion is pegged to the intangible valuation of these companies. So, clearly, I can establish to you that the intangible value is more than the tangible value of assets. And this is at a macro level. Now, I think Joydeep has gone through my background. I'm not going to bore you with my background. So examples of IP value, let's take Microsoft. If you ask someone, what is Microsoft? Is it a software company? Is it a hardware company? They will say either it's a software company or a hardware company or both. Well, if you look at the value of Microsoft's 1 quarter results in 2014, we looked at it, 70% of its $2 billion revenue in 2014 in 1 quarter, and 94% of its gross margin was from patent licensing. not selling products like software, hardware, not selling services, but pure licensing of the patents that Microsoft owns and owned at that point in time. So, this is a stark example in terms of how patents drive value and revenues, real revenues for companies. Technicolor, some of you will know them as RCA, which was the older television company. Again, licensing revenues for Technicolor in a single year from patent licensing was 118 million euros. And that's still been growing year over year. Technicolor has about 40,000 US issued patents. Qualcomm. If you own a mobile phone, which everyone does, and it has a CDMA chip, which many of you don't have CDMA chips in India, but Qualcomm makes its revenues, a third of its revenues come from licensing of its patents. So again, a very remarkable example of a company relying on its patents for its overall profitability and revenues. And then the last example, IBM, who I'm sure everyone knows. If IBM stopped their patent licensing business today, they would have to generate another $20 billion in sales to match up the profitability that they make with their patent licensing business. So clearly, it's a very, very important business for IBM. And IBM has always been in the top 5 companies in the world in generating patents and one of the most innovative companies in the world. So that's again the 4 examples. Then let me give you another example, which if you are in the intellectual property world, you are very familiar with. So when Nortel Networks went bankrupt, they had a massive number of patents in the networking arena. And the patents were so valuable at that point in time to a company which didn't have many patents, was not that large of a company, but was growing very fast, was Google. Google wanted to buy the patents from Nortel Network for $1 billion. And everyone thought that price was, just out of whack. It was too much. What happened next was even more surprising. The 2 arch rivals, Microsoft and Apple, got together to beat Google out and to buy those patents. So they formed a consortium, and that consortium then went and bought all of Nortel's patents for $4.5 billion, very large number. Google actually missed out. They could not buy the patents. And so they were in a difficult situation because they were a growing company but didn't have many patents. So what Google did after that whole transaction took place and they could not successfully get those patents, they went and bought a whole company, Motorola, for $12 billion just to acquire the patents that company had because they could not get the Nortel patents. Long story short, basically this was the first time that a company, when it was being sold post-bankruptcy, the value of their patents were actually more than their tangible value of all of the other properties, the lock, stock, and barrel, as we call it. So this was a good data point to show that patents are truly valuable. By the way, each patent in that portfolio was valued at $750,000 in the Nortel portfolio. And the 2 other quick examples that I will give to you, one was Microsoft, AOL, and Facebook. So Microsoft, when America Online went out of business, bought the patents for $1.1 billion from AOL because it was very valuable fundamental patents. And then Facebook was in a similar situation as Google was that I talked about before. And Facebook wanted also to buy those patents. So what Microsoft did is they bought the patent from AOL, and then they flipped around and sold the patents to Facebook. So both Microsoft had a license to those patents and Facebook had a license to those patents, and they owned those patents. So it was a good deal for both companies, Microsoft and Facebook. And truth be told, companies do that to avoid future patent litigation from these patents, which I'm not going to cover, at least in this talk. But it's a fascinating dynamic for someone to understand that. The next company you will all know, Kodak, which actually did very well for a while, but they missed out on the digital imaging side of things and were not very successful. So Eastman Kodak sold their patents, the entire portfolio, for more than $500 million. And the reason I showed you all three data points is to establish with you at a single patent level how important and how valuable, economically valuable a patent can be as a property right. So let me just shift from, again, the micro to a broad macro level. So the global trends in research and development spending. So if you look at this chart, which is actually put out by Battelle, which is based out of Ohio, right here where I'm standing in Columbus, Ohio, you will notice in the bottom, the x-axis is the percentage of spending, GDP spending in research and development. And on the y-axis is the number of scientists and engineers per million people. And in a way, I think this is a direct representation of the innovation that a country, that economy is doing. And it's no surprise you see, countries like Japan and South Korea who are spending a tremendous amount of money, percentage of their GDP in research and development. United States is a huge bubble, as you can tell, in terms of the total amount of spending in R&D, as well as in terms of the number of scientists and engineers. If you look at India, which is in kind of the bottom left, and the percentage of GDP spent in India is somewhere between 0.5 and 1% of the GDP, and also the number of scientists and engineers is not that many. So this is a good example of the pure innovation that is taking place. And the way I separate out innovation and intellectual property is innovation is coming up with the idea. Intellectual property is taking that idea and protecting that idea so that no one else can actually use that idea anymore. It is your proprietary property that you can use. And that's really what a patent fundamentally is. And I will get into the patent primer in a few minutes. But this shows you the one bubble that I want to share with you is in the middle right there, which is China. China has done phenomenally well. It did not even have a patent system 15, 20 years back. Now China produces more patents than US does on an annual basis. And when we say intellectual property in China in one sentence, people perceive that as a negative, but you would be surprised and shocked how well the Chinese intellectual property system is doing over the last 2 or 3 years. So, it's not a matter of just saying, they are copying things, because they are not. I mean, if you look at some of the Chinese companies which are creating new ideas and new patents, it is remarkable, especially in the area of artificial intelligence, machine learning, blockchain, some of the up and coming technology areas. So that's something to observe. So what I did specifically for this crowd is I took a snapshot in 2014 that you see right there. Let me actually move my screen here a little bit. And I took a snapshot of 2020. So now you would be able to see how things are moving along. South Korea, it's a little easier to do things. It's a small country, much more controlled. So it's not like a country like India or some of the other countries that you see sort of on the left side. But again, take a look at China in the bottom. They are about the same size in total R&D spending as the US is. And that bubble is growing every year. So, it's needless to say, whoever is doing the most amount of innovation will have a direct correlation with the amount of intellectual property that they create. And that is the country, that is the economy that will win overall in terms of how well it does. Because your intellectual property in that country will drive the products that are not generic products. And that's where I come in and talk about, if you look at the pharmaceutical industry, there are lots of countries in the world, but the number one country which produces the most number of pharmaceutical products which are protected through patents is still the US. And if you look at some of the Fortune 100 companies in the world, most of those companies are based in the US. And there's a good reason for that. And that economic reason, the R&D spending, the number of scientists and engineers who are actually doing that. But it's also not surprising that many of those entrepreneurs actually in the US who are creating value are people like myself and others who are coming from India to the US. You look at Satya Nadella and Sundar Pichai, and of the top 5 companies of most value in the world are led by the first generation people who came in from India. So this whole notion that innovation does not happen in India, I don't believe that. And people are not entrepreneurs in India, I don't believe that, because there are thousands of times more entrepreneurs in India than we have in the US. So that's kind of the bottom line that I wanted to share with you at a macro level, that innovation is not the same as intellectual property, and intellectual property is what drives a product's value that you will buy based on its innovation and intellectual property, as opposed to a generic product. So now let's dive into what is intellectual property. So intellectual property, if you look at it fundamentally, there are 4 different kinds of intellectual property assets. One is, number one, the most valuable asset in the intellectual property world are the patents. The number 2, trademarks. And I'll go through quite a bit of detail in patents and trademarks. Trade secrets and copyrights. Let me dwell a few minutes on trade secrets, because I think India runs mostly on trade secrets. The patent and trademarks are there. Maybe some of the trademarks you will recognize, and Reliance, big trademark. Yeah, I mean, you've got lots of other Indian companies. Tata is a huge trademark. But overall, patents are not as important in India as it is in, say, Japan or South Korea or US or some of the other places. So trade secrets fundamentally is what drives innovation to intellectual property, and that is kept on, through families, generations, businesses, whatnot. Copyrights are clearly not as important or as valuable as the 3 other types of assets that I talked about. But if you will, everyone owns a copyright. So if you wrote something down in a piece of paper, that is your copyright. Okay, nobody can take that away from you. But if somebody stole that from you and they started publishing on their own name on the web, or published a book, for you to go and stop them from doing that, that copyright needs to be protected. I don't know the copyright system in India, but in the US, if you don't register a copyright, then you don't have that right of going after someone and deriving that damages if they stole your intellectual property, copyrighted intellectual property. So copyrights are somewhat important, but not clearly as important as a trade secret, trademark, or patent. So let me then dive into patents. So, it's a funny slide there, but really on the right side, what you see is actually the most valuable patent that's ever been written. And some of you might be taking that drug every day. It's called Lipitor. It's the chemical name is called atorvastatin. It was Pfizer's number one product worldwide for many, many years, almost 10 plus years. And they were deriving between $15 to $20 billion from that one single molecule, Lipitor, which lowers cholesterol for humans. The interesting thing is when Pfizer went through the whole process, it probably cost them, more than $1 billion to get that drug to the market. But and they were making, lots and lots of money. It was saving lots of lives. So, it had a tremendous impact from that one single product. The interesting part that we find as IP professionals is the day the patent expired, that whole franchise of Lipitor dropped in value by more than 90% in a day. So the day your patent is gone, all the generic companies can now come in and manufacture that same molecule because you only get exclusivity for 20 years. That's it. So patent life universally around the world, as far as I know, definitely in the US is 20 years, but in most countries as well, it's 20 years from the date of filing to the date of expiration of that patent. And during those 20 years, you can have exclusivity in the market where you have a patent. And I'll talk a little bit more about that. The other one, which is really valuable, is Apple's iPhone, just a touch screen. And if you look at that patent, that fundamentally is tremendously valuable for Apple when they brought out the iPhone and the iPod and those kinds of things. So 2 examples, one in the life sciences arena, one in the tech arena. So what is intellectual property, really, from a legal standpoint? From a legal standpoint, it's the legal rights which a country actually provides to the inventor to derive some economic benefit to that inventor or creator, and public access to that invention, and promoting creativity and dissemination of knowledge for that invention. So let me break that down for you. So patent is actually a monopoly. So because you came up with the idea in the US, say, the government gives you a monopoly for 20 years. Well, what do you have to do in return? What you have to do in return is share with the world how you actually create value out of that idea. How is that invention created? So if it's a windshield wiper, how does that wiper work in taking out all of the water, and what is the motion of that wiper? So the details of that invention needs to be laid out in a patent and disclosed to the world, so the world can actually make improvements on that idea. Because you're doing that part, which is your part, sharing with the world how that invention was created and how it's used, the best mode of use, the government is giving you in contract the monopoly. So that's really the fundamental basis of what intellectual property is. And if you look at the US law, the US patent system is derived from its constitution, which is so fundamental. And so, it is the fundamental right, like owning the house that you have or the land that you have. So effectively, a patent is a property right in the US. The other thing that I will share with you, which a lot of people don't understand, is patent is not the right the government gives to you to go make money. The patent gives you the right to exclude others, meaning if you own that patent, nobody else can come in and actually practice that patent, that invention that is written in that patent. So it's a negative right as opposed to the right to go out and make money, which is what most people think of what a patent is. And that, I think, will also give you conceptually how a patent is protected. And I can go on and on in terms of how a patent is a personal property, just like your own home that you own. So for a patent to be, for an idea to be patentable, it has to meet 3 bars in every country. It has to be useful. That's actually relatively easy to show. It has to be novel. What does novelty mean? Novel means that the idea, whether it was created in Ukraine or in India or Brazil or US, it has to be novel, period. It has to be novel worldwide. So if someone in Poland created the idea in 1990 and you're trying to protect that in 2021, you cannot protect that idea because that already was there existing in the world in some way, shape, or form. The language doesn't matter. The form of it doesn't matter. It could be on the web. Somebody wrote an article on the web, or had a publication in Nature or Times of India. Any kind of publication which is out there publicly is called a prior art. And if that exists, you cannot get a patent later on in any country, anywhere in the world, period. So that's what novelty is. And it's a very important concept to understand that novelty is absolute. Must be non-obvious. That's a little bit difficult to understand. So, I'm a chemist, like my father was, and the way I look at non-obviousness is if you have a molecule and you have a chlorine there, and you said, okay, I'm going to change that chlorine to another halogen, and let's say I add a bromine to that. That is obvious to a chemist, and basically you cannot get a patent just by changing that molecule from a chlorine to a bromine. That would be obvious. So that is the bar that someone skilled in that art, a chemist or a mechanical engineer in the field of engineering, or electrical engineer or scientist, if it's obvious to that person from the original invention, you cannot get the new invention as a patentable subject matter. So those are the three primary criteria for getting a patent. What can you not patent? Abstract ideas, laws of nature, theory of relativity would not be patentable, for example, if it was created today. You cannot have the Newton's laws of motion patented. That is not patentable anywhere. Things that occur naturally. There was a huge discussion at one point in time in India, the alkaloid from neem, can that be patented? The answer is no. It existed. So something discovered cannot be patented. Something invented can be patented. So if you took that alkaloid and you modified that in some way that it's chemically now synthesized, which does not exist any place in the world, yes, it's patentable. Mathematical algorithms cannot be patented. So, binary theorem or Fibonacci series, any of those things, you cannot patent a mathematical algorithm. Now, having said that, you think about it, what is a software? Well, a software basically is a bunch of mathematical algorithms that produces a certain output. And software is fundamentally patentable. And there's a lot of discussion that you can have, but the way we patent a software is we tie the software with a piece of hardware. So if you have a database, you tie that with a physical computer, a server, and say, okay, now the software is actually working in conjunction with the hardware, so hence it is patentable subject matter. And the patent office actually allows that. Like I said, with things occurring naturally, you cannot patent that alkaloid in neem or Taxol, for example, which has been used for anti-cancer drug. It was a University of Florida State University's invention. So Taxol, the property of Taxol in dealing with cancer is patentable. The compound itself is not patentable. So the use of that compound is patentable. So having said those, non-patentable subject matters, there are certain applications that you can actually patent. The other thing that I will also tell you is if you have a bunch of inventions which are patented, so fundamentally you cannot go back and re-patent that. Once your patent expires, it's gone. A combination of all of those ideas is patentable because that's novel. If you take those 4 different ideas and match that into something which is different than each one of those individually, that is patentable. So that I would say is fundamentally you should keep in mind when you're thinking about a patent. So not going to go through this. Yeah, so I think we've covered most of these things. The expiration of a patent is 20 years. And you need to maintain a patent. So in the US, there are 3 maintenance fees that you have to pay, which is basically 4, 8, and 12-year maintenance fees, and they're escalating fees. There are different kinds of fee structures and whatnot that I'm not through, but it is suffice it to say that the fees are to ensure that you think your patent is valuable and hence you maintain it. In the Europe patent system, it's called an annuity. So every year you pay for the patent to be maintained. And if you don't pay the annuity, then your patent expires. So what are the critical elements of a patent? You have the specification. If you ever read a patent, then it's a very long, technical, hard to understand document, unfortunately. And the specification lays out everything in that invention. So how you synthesize it or manufacture it, what is the use of that invention, all of that. And then there are drawings. So I showed you the Lipitor structure. So that would be one of the drawings in that patent. Don't worry about preferred embodiment. Claims are basically at the end of the patent, and that is actually the most important part of a patent. And the claims will define what your invention is in that patent based on your specs, specifications, drawings, and other things in the patent. And let me take one example to explain to you how the patent protection actually works. So both houses look nice. One is a Italian style villa on the left with a swimming pool. It's a humongous house. And on the right is a small, nice, cute little mountain view property. And if the question is, and I'll answer it for you, which property would you prefer? I think in a logical world, everyone will pick the one which is the very large Italian villa, okay? Same thing in a patent. So in a patent, your claims should be really broad. So when you're applying for a patent for Lipitor, let's say you're Pfizer and you're applying for a Lipitor patent, you don't apply for that one single molecule. You apply for every combination and permutation of every single atom that could be changed, and it could run in the tens of thousands of molecules that you apply for rather than applying for that one single molecule. You want that to be as broad as possible as a claim. And this is for the basic reason that I explained to you before. It is the right to exclude others. So if you had just one single compound, then people could come in and just change a single thing, and then they could start selling it. But if you had 10,000 of those, which covers a much broader area, they obviously cannot come in and encroach in your intellectual property. That's kind of the fundamental idea, is keep your claims as broad as you possibly can. And the negotiation that you have with the patent office to get the broadest way of protecting that idea, that is called the patent prosecution. And that patent prosecution happens back and forth with the US Patent Office here, where it could take somewhere between 2 to 5 years for the patent office to allow you to have the patent issued. So that's your process. So try to keep your claims as broad, your invention as broad as possible, but yet have the specifics of your invention in the patent so you can go out and sell your product with that patent protection. So we just covered that, and think of this as, that you own a castle and the castle has a moat around it, and that moat really protects your castle. That's your patent, which is allowing you to protect that whole property there. So that, I think, is probably one of the most fundamental things that people need to understand about intellectual property, that it is a negative right. Try to keep it as broad as possible, and try to be at the same time be as specific as possible in your claims. So there are independent claims, which are very broad, and there are dependent claims, which are very specific, that allow you to capture the essence of your product. So you have both the broadness and the narrowness, and overall that gives you the coverage for a patent protection. So the types of patents in the US, utility patents, which is predominantly the largest form of patents. There are design patents. If I had showed you my iPhone or my Samsung phone right here, you would know from a distance, whether it's an iPhone or a Samsung phone, just because of the design. And believe it or not, Samsung and Apple both have patents around that design. And the difference is there is no utility in that design that you see, but there is distinction, and that is a design patent. And then on top of that, we also have plant patents, which I'm not going to get into that because that's a very difficult topic to kind of comprehend, especially if you're sitting in India. But there are patents around plants that you can have. And then the last one, which is sort of the international patent or the patent cooperation treaty, which allows you, if you're sitting in India and you had a new idea as an MSME, and you wanted to have a protection all around the globe, and you don't have the budget at that point in time, what you do is you apply for a patent cooperation treaty. And I think I have that later on. So PCT, as of 2019, there were 153 countries which were signed up for the Patent Cooperation Treaty, including the US and India. The notion is you apply for a patent as a PCT, and the system, the World Intellectual Property System, allows you 30 months to convert that into the individual countries. You still have to pay after the 30 months expiration, but at least initially you're not paying the fee for every one of those 150 countries. So in 30 months, then you can decide whether you want to go to Canada, Spain and India and Brazil and China, which countries do you want to go to? And that is a strategic decision that you have to make, and it's expensive. So on an average, a US patent costs you between $15,000 to $20,000 to get to issuance. So it's not cheap. I don't know what it costs in India, but I'm sure it's not cheap either in India. We have covered, I think, enough of the patent system. So just a quick review. If you're an MSME and you wanted to file for an invention that you've come up with, or you're a student and you really have a fantastic idea and you are at a university, at Amrita, Vishwa, Vidyapeetham, right? So you go to Joydeep and say, I would like to apply for a patent. The first thing that they might do is file for what is called a provisional patent application. A provisional patent application is basically a very cheap way to file for a patent. In the US, it's less than $200. And that allows you 1 year to file your full patent application. And during that period of time, you can actually call your invention a patent pending invention. And so you're basically buying time to see if there is commercial viability of that patent, and should you file a full-blown patent application, which could cost you initially between $5,000 to $10,000. So again, it's quite expensive. And then to prosecute that patent and get that patent to issuance, you need another $5,000 to $10,000 to get that patent issued. So unless you have economic value and somebody else or yourself, you are looking to take that product to market, you will probably not file for a patent application. So we covered what is an international patent, what is a utility patent, so that's patent primer in a very quick kind of nutshell overview. Trademarks. You can probably guess what are the most valuable trademarks, and if you look at it, this is one of the analysis that I picked for all of you today. Amazon's trademark, at least in this analysis, was the most valuable one. Just the Amazon trademark itself is valued at $220 billion. That's a staggering number. Google at $160 billion, and Apple at about $140 billion. So all of those names and recognize, and that's the reason it has value. So if somebody came to you and sold you the same iPhone without the Apple logo, and it's not made by Apple, I can guarantee to you that product will not be as valuable as the Apple product. Same thing with Samsung, so forth. So there is an inherent value with a trademark. The classic example that I give to most people is, everyone knows Coca-Cola, right? So if you have a Coca-Cola versus a regular no brand name cola, people will pay a premium price for Coca-Cola. The reason for that is they recognize it. There's a good value associated with that brand. And that is the value of intellectual property. The differential in pricing that you're paying, 25 rupees for the regular cola and 40 rupees for Coca-Cola. I'm just making up a number. And that differential of 15 rupees is your value of that trademark or intellectual property. So that's how trademarks are perceived. So let me just dive in and tell you what is the different what are the different forms of trademarks. So you can have a design mark. As you can tell, the Nike swoosh is a great design mark. You can have words like Kodak would be a good trademark. Everyone knows it. A composite, which is the design plus the words. So that's the McDonald's. GE, we bring good things to life. That right there, the slogan is a trademark, and you can register that as a trademark. And there's some other kinds of things as well. So shape, color, sound, scent, motion, all of those could be trademarked as well. So the shape of that bottle right there, without even knowing who owns that, you can guess. It's a Coca-Cola bottle, and that's the shape. So those are all examples of trademarks. I'll just give you a very quick nutshell of what a good trademark versus a not so good trademark would be. If you think about it, Exxon, for example, it's a made-up word. Nothing exists as a word. That is actually a very good trademark. If you think of Apple, nobody would have thought Apple is the trademark for a computer company. So that is somewhat arbitrary. It's actually a very good trademark. Then you get to more suggestive things, very check. Okay, you understand it's verifiable checks. So that is an okay trademark. Bad trademarks are, excuse me. So coaster cards or soda, these are trademarks that a US Patent Trademark Office or any patent office for that matter will not allow. So you have to apply for a trademark. And again, as an expert on the US side, I can tell you that just by using the name in a company, people have certain rights to a trademark. So you don't necessarily have to register. But the same thing that I said about copyrights, with registration, if somebody else is using your trademark, you can actually go after and file an injunction, to stop them from selling products with your own trademark. So there are certain rights that you can have, and typically, if you notice, trademarks have a TM. The TM means that you have applied for a registration, and the R, which is in a circle in trademarks, that is after you get the registration from the patent office. So those are the kinds of nuances of trademarks that I think is very helpful. Typically, if you're a company like a GE, then you would want to have a combination of various forms of intellectual property. And the strongest, obviously, like I suggested, patents are the strongest form of IP, but consider having a trademark and a patent protection. Tylenol, for example. So acetaminophen is the drug, right? And you can have, so good example in India would be Calpol. So CalPol, you know that brand, right? Even though it's generic, the trademark itself allows you to identify what it is. So a combination of, if you have a patent and a trademark together, that's better than having one over the other. The other wonderful thing about trademarks is it never expires. So as long as you're paying the fee and as long as you're using the trademark, it is forever. But the patent expires in 20 years. So effectively, you can still maintain the product viability in the market if you have the trademark associated with a patent. And software, you typically add copyright protection to add on top of a patent and your trademark. So Microsoft Office would be a good example. So you have Microsoft Office, you have a bunch of patents which is protecting it, and then you have copyright protection on top of that. So that's a 3-layer combination of intellectual property. Skip that. So let me now shift over to, how are we doing on time, Joydeep?
I think you have another 5-10 minutes. That's all.
Okay, all right, excellent. So let me just end my talk with the university technology transfer. As Joydeep mentioned, I've led 3 major universities in the US for technology transfer, technology commercialization. I started out in Nebraska, and then I went to Rutgers, and the last that I led was Ohio State. So I have seen almost 80 plus startups formed, and I have been involved in various startups at various stages. So I've been an entrepreneur, just like Joydeep said. Now I sit on the board of a publicly traded, NASDAQ traded company. So I've sort of come the full circle. And to be honest with you, what people don't realize is how painful it is to be part of a startup. And most of the times, 90% of the times you fail. Okay, and that is a given in any startup. So let me show you what universities have been able to do in the US as a powerhouse for innovation. So between 1996 and 2005, universities have created economic value to the tune of $1.3 trillion from the research that they have done. And again, the number of dollars is immaterial. I think the impact that it has had in the lives of people is just absolutely enormous. So you look at 200 plus drugs have been created by university research in the US alone. If you combine probably 100 different countries, they have not created that many drugs. So that in itself should tell you that research and innovation that is happening even at the Indian universities is critically important. If you're an MSME and you're trying to figure out what innovation should I be looking at to make my products more valuable, to save more lives, to have more impact. Those are the kinds of things. And I'll just very quickly tell you the favorite invention that I've actually helped in taking to market was by Professor Joachim Cohn at Rutgers University. Very simple invention. It's a polytyrosine, an amino acid based polymer that he created that dissolves at various rates. So he created these pouches, mesh pouches, and that was coated with antibiotics. So people, if they have a pacemaker, and if you insert a pacemaker, 4% of those people actually die of infections from that ICD device, the pacemaker device, because of infection. So his invention was you slip in that ICD device in that pouch, the polytyrosine-based pouch, which is coated with an antibiotic, so it prevents infection for a period of time, and then that mesh dissolves away. So there is no mesh left. And that to date has saved 50,000 lives in the US from that invention. So economic factors set aside, the number of lives that these inventions can actually save is actually enormous. So I was part of that whole transaction in getting that technology to market. So, there is a broader impact that technology transfer has had in the US. That would not have happened but for these two visionary gentlemen, Senator Birch Bayh and Senator Bob Dole, who created the Bayh-Dole Act in 1980. What that allowed is the universities to own that intellectual property, which in a strange way, if everyone has ownership of the IP, nobody wants it because no one has a monopoly. If a university has ownership of the intellectual property from these billions of dollars of research, then they can license that to a company, and that company can take that product to market, because now the company has incentive to take that product to market, invest money in taking that product to market, and then have a profit mission, as well as a mission for saving lives or whatever else non-economic value might be. But that was the fundamental reason. It's a policy-driven field that was created that I have been part of from both sides of the fence. And just to give you a very quick overview, the number of startups that have been created, clearly, you can see MIT as being the number one. They have created 244 startups from MIT from 2008 to 2018. So much so that Cambridge, Massachusetts is now the center of venture capital, at least one of the centers out of the Silicon Valley, where you see startups getting created from MIT, from Harvard, from all of those great universities. And then you see all of the other universities kind of laid out who are producing a very large number of startups, which are very valuable. Not going to talk about value of death. Let me just very quickly dwell on university industry research objectives. So that is critically important because industry a lot of times does not have the ability to do research and innovation, which a university does, but the missions are different. Industry wants profits and R&D. University obviously wants teaching, research, service development, but there's an intersection that actually works for both sides. Let me skip that. The interest of time. So again, if you look at overall the startups created from the universities, 1998 to 2018, it's about 1,000 startups that we are creating from the universities in the US every year. And these are very, very valuable because if you look at it, Google was a university startup. Genzyme was a university startup. And you can go on and on in talking about the products and companies that have been created by university researchers, the intellectual property that has now become the fundamental value for that company and spinning it out. So with that, let me end my talk. Thank you so much for your attention.
Thank you so much, Dr. Nag. I think it was a very insightful talk, and as the messages as I get as you were talking, it's extremely informative, and I think it's extremely insightful. But I've got a very interesting question, so I will not get into too much of a trigger, but I will still have one question because that nags me all the time. One of the issues of this patent creation is also creation of value. And that is intrinsically linked to entrepreneurship. If you look at the landscape in India, entrepreneurship is in a pecking order, very, very way down in the scheme of priorities of bright students. So how do you change that mindset? And unless you change the mindset, you cannot get patents, you cannot get the whole flourishing, the blossoming ecosystem out there. So how do you change the mindset in India? Any thoughts?
Yeah, I think that is a very fundamental question, a very good question, especially from the Indian, mindset standpoint. And I think it actually, it's a bit self-serving, but I think the fundamental reason for that are two. So one is the risk appetite. If you are in India or Japan, the appetite for risk is generally low. And the reason for that is failure is not seen in any way, shape, or form as a positive. Here, when we look at an entrepreneur, we actually will look at how many times has the entrepreneur actually failed. So did they gather enough experience to do what they're doing this time around? So it's very typical for a serial entrepreneur to have failed 5, 6, 7 times, and then they're successful. That is a badge of honor. So that's one. That mindset is just not there yet. The second is, in India, most of the businesses are small businesses. They are started by entrepreneurs, but those businesses are not based on an innovation such as an intellectual property, a patent-driven product. So inherently, your margins are much lower. They're services. They are products that don't have that wow factor, if you will. Not everyone is a Tata or Reliance or doing things at Wipro as a Azim Premji, right? So I mean, these are far in between. The very few entrepreneurs who've made it. So I think two things potentially could happen. Number one is share the successes, the stories of entrepreneurs who are going out and making it big. And I think that is happening. I mean, if you look at the number of startups now that's coming up in the hubs of, Gurgaon and Pune and Bengaluru, Chennai, I mean, it's commendable. So it's happening. And venture capital, risk capital is coming in slowly but surely. So you see that there is this inflection point. There are a lot less number of people. If you asked 1,000 students at your university, would you like to go to the US? I think the answer would be very different than what it was back in 1992, when most of the people wanted to go to the US. And the reason for that is, they see that there is an opportunity to do it in their generation. You don't have to be from the Tata family anymore to go launch a healthcare tech company. You can actually make it big. So I think, you see that dynamic is shifting, but it's a slow process. And at the end of the day, there's a role that the government has to play. The government is not risk-taking. It's understood, but the government has to be responsible both at the national level and at the state level to drive the policy that paves the path for startups to happen, entrepreneurship to happen. So that
Absolutely.
would be my answer.
Absolutely. I think the fundamental is the right to fail and the right to fail. I think till that mindset comes in, it's a long shot. But anyway, I have got a number of questions piled up. So let me just shift to those questions. And those are very interesting questions. The first question comes from Indrajit Banerjee, who was written it some time back. And he says that, with my long years in the pharmaceutical industry, what are your thoughts on why we find companies in India find it so difficult for companies in India to file global patents compared to US companies who get global patents so easily? So what are your thoughts on the same?
Yeah, and Indrajit, that is an amazingly good question. And I will tell you the answer, the secret that is well kept in the US is, it is actually not the pharmaceutical companies in the US who come up with that innovation to file the patents. It's the universities. There was a study done by Dr. Ashley Stevens, which I'm happy to share with you offline to Joydeep. And Dr. Ashley Stevens, a very close colleague of mine at Boston University, looked at 15 years worth of products from the pharmaceutical industry in the US. What he found was astonishing. 84% of the products in the market by pharmaceutical companies was from the university or had touched the university in some way, shape, or form. So I think, when pharma, tries to go do it alone in India, it does not work that way. No company will have all of that, innovation mindset within the company itself. They have to look outside. So I think that's one. The other thing is, it's easy to be in the generic business. And that's kind of the challenge. Would you rather make 80% margin and work with a tremendous amount of risk, which costs you $1 billion+ to get a drug to market? Or would you rather take a 5 to 10% margin and it's a slam dunk? As soon as the patent expires or you go invalidate that patent, you go manufacture and make money. I think the second route is a lot easier to take. And that's exactly what pharma industry in India has done. Nothing wrong with that, but that does not produce new products or new patents or new innovation for that matter.
But I have an attendant question. You said that most of these patents have touched the university at some level. Okay, we have Indian companies which do a lot of R&D research, etc. You're right; they are largely generic, but they also do R&D research. But why is it difficult to get, and why does going through a university make it much better? What is the difference?
Yeah, so I would actually break down, the notion of, a company does R&D. A company mostly does the D, not the R. So it's research and development. Universities are much better equipped to do this blue sky fundamental research as opposed to a company which is driven by profit motivation. The same thing, if you look at pharmaceutical companies here, they go through the clinical trials. They're very good at it. Universities will never be able to do those clinical trials because it requires all these regulations and money and all that stuff, right? So I think the division of labor, if you will, the research is well done, fundamental research very well done by universities, and then the company needs to take that innovation and productize it. That's not productized. So the intellectual property creation, the product creation is really the responsibility, in my opinion, of that company to take it forward. And that in India has not existed so far.
Yeah, got it. So the next question comes from Ramchandra Setu Sutar, who says, any microbes can be patented?
Any microbe can be patented? The answer is no. A microbe cannot be patented unless that microbe is actually created by human. Okay. And so in the event that you are genetically modifying a microbe and creating something that does not exist in nature. So you go back to the slide that I showed to you. If that microbe existed in nature, then you didn't create it, you found it, and hence it's not patentable. But if you created that, then yes, it is patentable.
Okay, great. So another interesting question which has come up is, if I am developing a model using deep learning techniques, whether it can be a patented one?
The answer is it depends. If you break it down, a deep learning technique is nothing but a machine learning or an artificial intelligence machine, right? And that AI can be fundamentally broken down into software, right? So that software algorithm that you're creating, software, like I said, it's hard to patent unless it's in conjunction with the hardware. But if you are producing unique output from that ML model, yes, it is potentially patentable.
Okay. The next question actually comes from Dr. Mallikarjun, who says, what is the difference between an Indian patent and an US patent? There may be very fundamental differences, but if you could take a jab at that.
Yeah, so I'm not a patent lawyer, so I'm not going to go into the legalities of patents, but fundamentally the difference is, if you have a patent in India, you can protect your product with that patent in India. If you have a patent in the US, you can only protect that product in the US. So patents are very jurisdictional or territorial. So if I have an idea and I wanted to protect that idea in the US, then I would file a US patent. If I wanted to have that idea protected in India and US, then I would file both. Okay, so that's the fundamental, sort of property right. The nuances of the Indian and the US patent system, it would take us 7 days to discuss it. Okay, I wrote a paper on the pharmaceutical differences, which again I'm happy to share with Joydeep. We published an article when India was going through its IP policy changes on the pharmaceutical side, and so there's lots of nuances on various fields, and every country, a sovereign country has its own way of doing things. You don't have to copy things from Europe or US. You have your own system. So it's fundamentally different that way. So I would say, the basic thing is, I would say just the territorial nature of the patent is what is the difference.
Yeah, this actually brings me to an interesting question, and I'll read it out to you since you talked about territories. There have been many people who are going for Australian patent. Is this a viable option, or should I go for an Indian patent?
Yeah, so the answer is yes. It is absolutely a strategy, because the Australian Patent Office is very efficient. They give you an answer within 6 months, I believe. It costs much less. But look, if you are looking to have a product that you are going to sell in Australia, yes, it is a good idea to go and get an Australian patent. But if you are looking for selling that product in India, then you going into Australia doesn't help you much. So you have to pick which regions in the world, which countries in the world are most important for you to have a patent, okay? From a national patenting strategy standpoint, it makes a lot of sense to go to Australia first, because you get an issued patent the fastest. And you can then use that issuance in various ways that I'm not going to get into in detail here today, with that issued patent in other jurisdictions around the world. But if your only intent is to sell the product in India, then your Australian patent is going to be useless to you, because you're not selling in Australia.
Yeah, but I've seen researchers who file their patents in US. They say that it's more stringent, and therefore the patent is more stands the test versus a patent elsewhere. So is that notion correct, or is that?
Yeah, yes and no. So everything that you said is true, but that's not the reason they are filing in the US. So the reason they're filing in the US is because US is the largest market possibly for that invention. That's why you file a patent in again, a jurisdiction. You're not filing in China because you have love for China, or you think the Chinese patent system is better or worse. The only reason you're filing a patent in China is because you will sell the product in China and you want protection in China. That's how, from a logical standpoint, you should be thinking about patenting.
Okay, that's very interesting. Dr. Amir Khushru Akhtar has asked a question. Is there any relationship between the number of patents filed by universities and the number of entrepreneurial ventures or startups created by the faculty or students? Is there any correlation?
Yeah, that's actually a great question. So having said everything that I said about patents, it's a question of budget. If you want to file a patent and get a patent issued, because you can get a patent issued for pretty much any idea. You might get a very narrow patent, and that's a different story. So, typically you are right in some way that innovation is directly proportional to the number of patents being filed, and is somewhat proportional to the number of startups that might be created. Because when we talk about a startup is just a modality. Startup is a modality in the sense that you could license it to a GE, or you could license it to a startup. Now, if you're creating a startup, by definition, you have an entrepreneur. Okay, without an entrepreneur, nobody is going to create a startup. So, your notion of saying, hey, is it the number of startups is it proportional to number of patents? In a way, it is. You will see a positive correlation. But there are lots of other factors that drive the number of startups and entrepreneurs. Number one being, where are you? Okay, so meaning if you're in Silicon Valley, it's a lot easier to do a startup because of the fundamental reason that you get a lot of risk capital, which is venture capital. People who are willing to take risk in your company because of your background, because of your track record. You will not go to a bank to do a startup funding, right? So long answer to your question, but I think it's a good one. You will find a positive correlation, but that does not necessarily mean that if you file a patent, the startup would be created or you will find an entrepreneur.
No, great answer, Abma and Dr. Nag. But I have, it intrigues me with another question, is that, Bangalore is a big hub for startups, right? So also, universities have not come up in that way, but Bangalore is a hub. So how to convert a Bangalore into a Silicon Valley? So what's your recipe in terms of 3 things that we need to do?
So number one, I will tell you, you will not convert Bangalore to a Silicon Valley because there's only one Silicon Valley. And believe it or not, I have got this question almost every region of the world that I've been.
Silicon Valley of India.
Correct.
The Silicon Valley of India, yeah.
Which is perfectly fine. I think, to get things going, the biggest thing that you can do is portray the success stories. So if you have a case study or two where you show that somebody has been very successful by creating a startup, you attract other people similar to that. So, the 3 legs of the stool, if you will, technology, you need risk capital, and you need entrepreneur. So those 3 things, the trifecta effect is what creates a startup. And that startup economy will trigger creating what you're calling the ecosystem, the startup ecosystem.
Right.
And that has happened in many parts of the world. So Tel Aviv is one of the best startup hubs in the world. Bar none. Okay, they're not Silicon Valley, but they're Tel Aviv. You take a look at Canada. Toronto is one of the best startup hubs in the world. Okay, Austin, Texas is now becoming a startup hub. North Carolina, Research Triangle, Cambridge, I talked about MIT, Harvard, and those kind of, universities. So you need that technology, that innovation piece. You need the risk capital, somebody who's willing to put money, risk their money in there. And then you bring in qualified entrepreneurs, not someone who's just saying, I don't have a job, let me go do a startup. That is not the person that you want. If somebody's looking for a salary from a startup, that is not your person to build a startup.
Absolutely. Great answer. So I have one more question, which is Dr. Akhtar, who asked the question on the, on the patent. One more question is that, is patent first and publish later, or publish first and patent later? Which one do you support and why?
So it's not a question of support, it's a data point. If you publish first, your patent is dead, period. There is nothing that you can do. If you publish first, you will not get a patent. Your publication becomes a prior art to your own patent filing. So it cannot be done. That's it.
Okay. It's a very simple and a short answer. That's great. Could you brief about process patents and some examples? What are process patents and some examples?
So there, in the US, there is one kind of patent, which is utility patent. From the utility patent standpoint, it could be a process, it could be manufacturing, it could be a chemical. It's one kind of patent. You can have all different kinds of claims in a patent. Having said that, the strongest patents are the composition of matter. So which means a chemical entity, a biological entity, that molecule is the strongest kind of a patent. Process patents are not very powerful, because if you have a 29-step process and you file that as a patent and you change the last step of that process, then somebody else can actually go use it. So your 29-step process just went down the drain in the patent because somebody changed this one step. So process patents, what I'm trying to say, are not as powerful as a composition of matter patent. But is it useful? Yes, it is useful from time to time.
Okay, there's an interesting question and a twist to this question. If something is patented and later found in nature, would the patent be non-existent thereafter?
Correct. It's not a valid patent.
So it expires with that, right?
It's not
in nature.
It's not expiring of the patent. It's basically the patent is invalid at that point in time.
Oh, okay. So you don't have the rights.
Correct.
Okay, so we actually have come just to the end of, there are many more questions coming in. I don't know what to do, but we'll compile those questions and send it across to you so that you have some time and leisure to answer those questions. But it has, let me tell you, it has been extremely insightful. It's a very informative session and a lot of things we didn't know. I think it was for us an eye-opener. Thank you very much for taking out your time. It has been a pleasure, an honor, and a privilege to have you with us. And we look forward to having you many more times. Thank you so much, Dr. Nag.
Thank you. Thank you very much.
Thank you. So with that, we'll close the discussion today and look forward to the next webinar. Thank you.